All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. Let all who have cause to plead draw near, give attention. You will be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Supreme Court of Florida, please be seated.
Good morning and welcome. Our first case today is Gessner versus Southern Company, number 2024-1835. Ready?
All right, may it please the court? At this time, I'd like to reserve 5 minutes for rebuttal, if possible.
I can't hear you. Mic closer to you a little bit, maybe.
Normally, I don't have that problem. No one's ever told me I'm too quiet before. All right, so may it please the court? My name is Ashley Richardson, and I'm here on behalf of Mr. Gessner, and I would like to reserve 5 minutes of my time for rebuttal. On the surface, it looks like we are here once again to have a lively public debate about the definition of the word is, rehashing the 90s, as it were. If we dig a little bit deeper, the issue is a bit more complex than that, and it stems from the provision within the Florida Private Sector Whistleblowers Act, a very narrow provision that offers protection, and this is 448-102 sub 3, offers protection to employees who object to or refuse to participate in any activity, policy, or practice of the employer which is in violation of a law, rule, or regulation. The is the issue here. My colleagues across the aisle, as well as the first, second, and now fifth DCAs, want that to be interpreted as literally as possible. That is means an employee, to preserve their claim and prevail in court, must show that the employer engaged in an actual violation of law.
Can we focus on the must show part? As a pleading matter, it's true at the sort of, if we just sort of take that statement over the life of a lawsuit, at the motion to dismiss phase, you may be right that the allegation, like any other allegation a plaintiff must make, has to be colorable, has to, there has to be a basis in fact for the allegation. At the conclusion of the matter, when submitting the question to a jury, is it your position that the preponderance of the evidence is the applicable sort of standard of what Mr. Gessner would have to prove to a jury in order to succeed?
Right, so that is one of the issues that we have with this actual violation standard, is that it drastically increases the burden of proof in what would otherwise be a remedial statute. Well,
but that's, I just want to establish first that we agree that in order to prevail and get a jury verdict, Mr. Gessner would have to prove by a preponderance of the evidence that there was a violation of the law. Are we on the same page so far?
Yes. Okay,
well then my question is, what is it that he must prove by a preponderance of the evidence?
So that is
that the violation, that the facts are as he alleged, in your view, or that in fact there was an adjudication or a violation of the law that has been established? What is his burden at trial?
I would argue it's the former, because if we're looking to the latter, where there actually has to be some sort of adjudication or maybe a administrative action, something like that, that's way beyond the scope of what the actual text of the statute says. And also, again, we're looking at a remedial statute that is designed to protect an employee.
Say we take the remedial statute sort of policy debate out of the discussion at the moment, and we focus just on what the original public meaning of the statute is. I just want to make sure that I understand what you're saying Mr. Gessner would have to prove in order to prevail.
I would say that going to an actual adjudication of some kind of wrongdoing on the part of the employer is several steps too far.
So we know that's not it, but what is enough?
I would say that so if we look at Kearns, which I disagree with on a number of levels, but I think that the standard that they applied to Mr. Kearns' claims when they actually were put before court, he established essentially a prima facie case of, I believe it was fraud under one of the specific Florida statutes. So he was able to at least show that the evidence said, okay, here's the different elements of fraud, and we have evidence to support all of that.
And how is that different from what he would have to allege at the motion to dismiss phase? I guess that's my quandary, is it doesn't seem to me, like, based on what you're saying, that his burden shifts at all over the course of litigation, whereas most of the time it would, right? We would expect a plaintiff at step one to have made an allegation, but at the jury verdict phase to have established something.
Right, and I think that's because we're sort of case within a case on this one, whereas his actual elements of his whistleblower claim might be very basic in the complaint and then evolve and sort of fill out over the course of the litigation, whereas the underlying thing that he blew the whistle on, those allegations are going to basically stay the same throughout the course of the proceeding. In order to survive the motion to dismiss stage, he's going to need to assert, this is what I believe they did, this is what I believe was violated, and then we'll just put the evidence together. But I don't think that that's going to change substantially throughout the course of the proceedings, even as we get into the trial phase, whereas his actual prima facie evidence under the whistleblower claim, that is going to evolve and grow over time, if that answers your question.
I'm going to back up from this a little bit. What do you say that the district court got wrong?
The definition.
That's why we're here, right? Yes. What did the district court get wrong?
The definition of the word is, unfortunately. So the district court followed the Kearns opinion out of the second DCA, which follows a middle district case, the White versus Purdue Pharma. And they say that the use of the word is a mandatory, literal, he must show that there was an actual violation of a law, rule, or regulation in order to proceed with his whistleblower claim.
As opposed to the employee having a reasonable belief that the proposed action or the activity, policy, or practice would violate the law.
Correct. That it's the.
Okay, so it's all about whether, and this actual is a little confusing because it's very clear from the context, at least to me, that doesn't have to have actually been a violation of the law that occurred. If a proposed activity, policy, or practice that the employee refused to engage in didn't actually go forward because the employee refused to engage in it, then the question is whether what was proposed or instructed or directed or required by the employer would have been an actual violation of the law.
Right, and that's our position, is that when we look to sort of those future actions, and it's the barrel of toxic waste example, I think, that was used in the NELA amicus brief. If the employee refuses his supervisor's instruction to dump the toxic waste into the river and goes and informs somebody, hey, this will be a violation of law, and he gets fired immediately, if we look at just this very literal actual violation of law, there technically wasn't a violation.
Okay, how does that relate to this case?
Well, so if you restrict one, you restrict it all, is essentially how it relates to this case. So where we have
No. Tell me, I don't understand. Give me the facts of this case what happened?
So Mr. Gessner, over the course of his employment, and this is sort of a construction manufacturing environment, reported a number of safety issues, just for brevity's sake, that he believed were in violation of various OSHA standards and not necessarily specific violations of a written legislatively enacted law. And our position has always been that he had a good faith, objectively reasonable belief.
So but all this is about whether good faith is good enough.
Well, I would say good faith alone is not good enough. We need to add the objectively reasonable standard. Okay. Otherwise, the employer does suffer from additional burdens that are not contemplated by that statute. So we would absolutely advocate that the reasonable belief needs to be there. Otherwise, we're all going to be in court all the time, which only benefits some of us.
Well, the first DCA and the second DCA take the position that the employee has to show that the employer actually violated the law.
Correct.
And you got the fourth DCA basically saying that the employee had a good faith, reasonable belief that the employer violated the law.
Right.
But the statute, the text of the statute uses the word is.
Yes.
So I guess what it says is that the way it should be read is that the employer is violating the law. So how does that, what do you suggest?
So we take the position that the good faith, and I may just say the good faith standard, but objectively reasonable is part of that. And that comes from the fourth DCA followed the Luna opinion, which was another district court case, which relied on the way Title VII has been interpreted. And if we look at Title VII, it says that it shall be an unlawful employment practice for an employer to discriminate against any of his employees because he has opposed any practice made unlawful by this section. So it's that same sort of specific language. And the way Title VII has been interpreted for like 40 years is that that's not an actual violation and objective.
But this text, I trip over the words of this text when you start talking about that, because it says which is in violation.
Right, and I agree with
and that seems to me to be pretty clear.
It does on its face, but if we look to, we have Title VII, and this is what White disagreed with, was that Title VII, it's a federal statute, that was federal law that was interpreted. However, if we look to the Florida Civil Rights Act, which is patterned after Title VII and interpreted in tandem with Title VII, it uses is. This is in 760.10 sub 7. It is an unlawful employment practice for an employer to discriminate against any person because that person has opposed any practice which is an unlawful employment practice under this section. So we have the same use of the word is, yet we're relying on
you've got a different statute, and you've got a rule of construction. Is that a statutory rule of construction?
That's the way it's been interpreted for.
Well, is that specified in the statute?
Within the text? No, it's not specified within the text.
Okay, so we've got something that's going on over there that's going on over there, but we've got this.
Correct.
And I'm just struggling with getting around this clear language based on these other things floating around out there. Because again, I'm not saying if this was unclear, that would be one thing, but it would be so easy for the legislature to say which the employee reasonably believed to be in violation of the law. I mean, that's what you want to be written in there.
That is what I'd like to be written.
That is what you want to be written in there. But that would be so easy for the legislature to do. And elsewhere in this statute, like right above it there, they talk about an alleged violation of the law.
They do.
So it's clear that the legislative mind was thinking about things that are kind of in this realm, and when they talked about alleged. So I don't know. Don't be skeptical. I understand your argument. It is the kind of argument that has frequently been successful, but it concerns me that it really runs up against this text, which seems to be pretty clear to me.
Right, and that I agree with, and it's I was going to bring up the same point about the use of the word alleged in the section that immediately precedes it. But if you actually look at 448.1022 and what it protects those who provide information to any government agency, person, or entity conducting an investigation, hearing, or inquiry into an alleged violation. The alleged violation is not something that the employee brought forward. This is something that was discovered elsewhere. They are investigating it because it's still alleged. It's not yet an actual violation. We're still sussing out all of those facts, but we're offering the employee protection because they've been dragged into this investigation.
I think there is a tendency on what I've seen in the briefing on this case is, on the one hand, there's an attack on the importation of the word actual, and then on the other, there's an attack on the importation of objectively reasonable.
Right.
And rather than sort of rehash that debate, I think what you're hearing from at least two of us so far is let's just take the words as they are and leave Title VII and its tests behind and leave actual out of the picture. This is why I started with pleading standards. It seems to me that one way to engage with this is what do you have to prove and when? Because if we just don't try to adorn the statute at all, one way to make sense of the fact that we don't know at time zero when you're making the allegation, say, that there is a violation of law, because there hasn't been an adjudication yet. Right. And it would be nonsensical to say, well, it must be an adjudication. That would be an absurd result. But on the other hand, you know, at the conclusion of the trial, at the conclusion of the process, you would have had to establish something. And it seems to me that that's one rational way to read the text as written, is to sort of ask, what must you establish and when? And so that I'm wondering whether you can help us understand what you need to survive a motion to dismiss, a motion for summary judgment, and to prevail on the merits.
Right. Well, and that, to that extent, I do agree that the sort of end game sort of justifies what happens prior to that. Our problem is the difference, and I know we don't want to use actual and objectively reasonable, but what are we attempting to even show the jury that we objected to? And I bring up Title VII because it provides a pretty decent example. Like, let's say, for example, we have a hostile work environment claim. A derogatory term is used in the workplace. I immediately run to my supervisor and I tell them that's not yet a hostile work environment, but I'm supposed to report that in an effort to prevent this future harm. So we wind up with a similar issue here. If I go back to my toxic waste barrel situation, if we see that something is going to happen that could potentially violate the law, the idea behind these statutes that protect employees who do this protected reporting.
So then in this case, let's leave the hypotheticals aside. Okay. You have your client is saying some very inappropriate things and is having performance issues and, is in a tricky employment situation and also alleges an OSHA reg violation. Walk me through the analysis in our case about what needed to be established and when. So
in our case, we would argue that he needs to, and he alleged in the complaint, and then obviously we dealt with this on summary judgment, that what he objected to, he had an objective belief that this was an actual, that this was a violation of law, that let's say, I believe there was an issue with fire in various small confined spaces, something along those lines that just from its face looks dangerous. There's fire, you want me to go in there, that seems like a bad idea. So he reports this to his supervisor. He has an objectively reasonable belief that this is a violation of safety standards and rules and regulations. And
you think, okay, so now he should be able to survive a motion to dismiss just on that?
Yes.
Okay, summary judgment.
Summary judgment. So now we get into this burden shifting analysis. He makes the same arguments that he reported these violations, or what he reasonably believed were violations of laws, rules, and regulations applying to the safety in the workplace. Now, this is where the protection for the employer comes in, because we've established our prima facie case. He makes the report, he is then fired. They're going to come in and say, okay, but he was a bad employee. He used a racially derogatory term. He did this, that, and the other. We wanted to fire him. That's valid. That's the legitimate non-retaliatory reason. We then have to come back and prove that that's false. And that's where we get in summary judgment, which is one of the issues we have on summary judgment, is we have to establish that that was false and that retaliation was the actual reason that he was terminated. So once we get past that, then we get to present it all to the jury, who can then determine, was his belief that fire in a small confined space violated a safety regulation? Did he actually engage in that protected activity? So that would be the process in relatively simple terms. And I do believe I only have 3 minutes left, so if there's no other questions, I'm going to save the rest of that time for rebuttal.
May it please the court, Matthew Gutierrez on behalf of Respondent Gulf Power. Your Honors, the respondents have agreed to split their time, with 15 minutes going to Gulf Power and 5 minutes going to Southern Company. This appeal presents a single question of statutory interpretation. To establish a claim under Section 448.1023, must a plaintiff prove that he blew the whistle on an actual violation of a law, rule, or regulation, or is it sufficient that the plaintiff demonstrate he possessed a good faith, reasonable belief that a violation occurred?
And when you say actual violation, you do not mean a violation that had in fact occurred. You mean it would encompass that, but it would also encompass a course of action that would have been in violation of the law if it had occurred.
So an instruction to violate the law is an instruction to conduct activity in the future. And the purpose of the statute is to prevent illegality and to promote opposition to that. So if you in fact object to the illegal conduct and as a result it doesn't occur.
That's proposed.
Correct. The instruction is to do something in violation of the law, rule, or regulation. That is sufficient. But the fact that it doesn't occur is what the statute is trying to accomplish. it's trying to prevent it from occurring to begin with.
Because
so it
you
can't-
object, and then you're protected for objecting to something that, if done, would be a violation of the law.
Correct. That is the definition of the protected activity. It's exactly what the statute is trying to accomplish.
But the way that you square that with the statute is to say that the instruction is in violation of the law. Because the statute says that there has to be an employment or a practice policy or something of the employer that is in violation of the law. And so if it were purely a matter of just prospectively doing something, that wouldn't be covered by the statute. But you're saying that under the facts where you've actually been instructed to do something, that in and of itself is as Tannenbaum says in his concurrence, that it's in a present state of illegality.
Correct. The instruction is to do something that is in violation of the law, and that is sufficient in our view. So, and there's been some discussion about adding the word actual to the text. We don't believe that the word actual is adding anything. It's part of the definition of is. So the text says that to qualify for protection, the conduct, the activity, policy, or practice must be such that it is in violation of the law, rule, or regulation. Is means the present indicative of be, which means to exist in actuality. The word actual comes from actuality. Is links the antecedent, which is the activity, policy, or practice, with the prepositional phrase in violation of law, rule, or regulation.
So I'll ask you the same question I asked your friend. What is it that what is it that a plaintiff has to prove to survive a motion to dismiss? If, for example, we're dealing with as we are here, an allegation of, as you've articulated this morning, I'm not hearing much disagreement with the other side. Mr. Gessner alleges a state of play, a state of facts that are in violation of OSHA regs, right?
We disagree, Your Honor.
All right, so help me understand the disagreement, because, I think the most aggressive reading of your position requires almost, as I said earlier, a sort of unreasonable sort of conclusion, an adjudication even, that there has been some sort of, violation of the law. So help me understand what you think a plaintiff has to prove at the motion to dismiss phase and at summary judgment if your reading of the statute prevails. How is it different than her reading of the statute?
So a couple things. On the OSHA violation, they're referring to the OSHA catch-all provision. What you won't find in their briefing is any argument that there was an actual violation of that standard. They have now abandoned that, and for good reason. In the trial court, the First District, in neither of those proceedings did they ever allege the 4 elements of the OSHA catch-all provision, 2 of which are conspicuously absent. The feasibility of mitigating the harm, there's no evidence of that whatsoever. They also have to establish that there is no other applicable OSHA regulation to the conduct in question, which in a power plant is going to be the case. So we disagree that they've alleged a state of play that there's an OSHA violation. With respect to whether there needs to be an adjudication that conduct is, illegal before the employee can object to it, of course not. But this is just like a wrongful death case that's premised on murder, and you have overlapping civil litigation and criminal litigation. It happens all the time. There are many high-profile examples of a criminal defendant having been found or acquitted of murder, but then being sued in the civil context and prevailing because the standards of proof are different. So whether or not a criminal prosecution or any other type of adjudication of illegality would have a preclusive effect in the civil case.
I lost you. What is it that Mr. Gessner has to establish to survive a motion to dismiss under your theory?
That the activity, policy, or practice is in violation of a law.
Would be a violation of the law if he actually did it?
If it's a forward-looking instruction, then he has to prove that the instruction itself was to do something that is in violation. If he's objecting to something that's already occurring, he has to be objecting to something that is in violation of a law, rule, or regulation.
So is it inevitable in these cases then that part of the litigation is going to involve how the objection was articulated to the employer, and then sort of the causal relationship between that and whatever the adverse employment action is. But then is there, and that's what the other side, I guess, in response to some of the questions, kind of jumped to that about, is it really, is there some other reason for the employment decision? But is it inevitable that the part of what's being litigated is just sort of, it becomes like a little mini trial within a trial on whether it's the instruction or whether it's something that has in fact already occurred? Does that violate whatever the alleged sort of law that's in play on the OSHA thing in this case? So in this case, so then as far as, so at the motion to dismiss stage, you'd have to just allege in your complaint something that, if true, would be a violation of the law. And then at the summary judgment stage, you would just be asking whether the record shows that essentially that, that there isn't any disputed material fact on that issue. But within this, it is kind of, it doesn't have to be adjudicated beforehand, but I mean, it is kind of being adjudicated within this proceeding, right?
A case within a case.
Right, so obviously it doesn't have any binding effect if OSHA decided to go after the employer or whatever, but I mean, that is substantively on the table in these cases.
Absolutely, yes.
I think that's a very significant, I want to make sure I understand that, because if it's to my mind, that's a very significant, I don't want to use the word concession, but so if, to play the Chief's hypothetical out, it's not a hypothetical, if OSHA ultimately established there was no violation in this case, after the fact, your case is fully litigated, and a year later, OSHA concludes there was no violation, you would still say that if the trial within a trial resulted in the conclusion that there was, you would conclude then that there was that Mr. Gessner had objected to an activity, policy, or practice of the employer which was at the time in violation of the law, rule, or regulation, even if you were ultimately decided to be off the hook by OSHA.
It's collateral estoppel. I mean, it's issue preclusion. If whether or not it has a preclusive effect, you have to go, and that's not been briefed, but you have to go through the mutuality of parties. Was it adjudication on the merits? Was it the same exact issue? So it's just like any other context where you have overlapping issues being litigated in different cases. There's no difference. We see it as the same. OSHA may or may not find a violation before or after. You're going to have a situation that arises when you have two cases that deal with the same conduct between different parties.
But if OSHA finds a violation before it gets litigated in the employee's case, then the employer's in a world of hurt.
Correct. Absolutely.
But if it happens after the fact, after it's already been adjudicated favorably to the employer in the employee's case, then that's just, why wouldn't that be res judicata? I mean, that's over.
Yeah.
But the whole business about, am I being instructed to do something, or am I seeing the possibility of something that, if it were actually carried out, would be illegal? Like, that's not really what this argument now is about. This argument is about, if I'm complaining about something, even in a good faith, reasonable belief that it is illegal or would be illegal if I did it, if I'm wrong about that, if the little mini trial within a trial says, look, yeah, they really sincerely believed and objectively thought this was illegal, but it's not, then the person would lose. Under your view of the law, they would lose, right? And that's what this is about.
Right.
It's not about like whether it's a prospective proposed thing that would clearly be a violation versus an actually consummated violation.
And there's nothing wrong with that outcome. I mean, the starting point at common law was that we're an at-will employment state. The legislature created a protection, and it was free to create a protection as broadly or as narrowly as it saw fit. And it actually picked and chose throughout the statute when to provide broader protection for alleged violations, as in subsection 2, and suspected violations, as in the Public Sector Whistleblower Act. In our provision, which is subsection 3, it says is in violation, and we have to apply the text as plainly worded. And they have now said, and my colleague on the other side says, she said it's clear on its face with respect to the words, and that's this court's exercise, is to assess what is the common and ordinary meaning of the words in the statute, and then apply that.
Is the difference between your arguments from a pleading standpoint, that the reasonable belief kind of pleading is, I believed this was in violation of OSHA, versus what you're saying from a pleading standpoint is the facts, if true, need to be in violation of OSHA. So from a pleading standpoint, I don't really understand the trial and a trial standpoint. It's just from a legal basis, could this be a violation of OSHA in the sense that if it's the catch-all, then there's a feasibility requirement, that sort of thing. Is that what you're saying from a pleading standpoint, or is the pleading requirement more?
Well, the pleading would just have to allege facts that, if true, violated the law. So in the case of OSHA, they would have to go through all the elements and allege facts that satisfy all 4 elements. We don't even know what the elements are. I do, but it's not in the briefing because they're not asserting an actual violation anymore, and they barely did so below. What they did was they had a shotgun style. All these bad things happened. There was fire, there was hydrogen, there's coal in this coal plant. I think that that's flammable, so therefore all that I reasonably believe violated OSHA, but maybe it also actually violated OSHA. And there was one line in their briefing in the first district that said, oh yeah, by the way, all that stuff is a violation, after saying that he reasonably believed it was a violation. So what we have in this case is, in our view, somebody who is identifying through common sense. They're working in a dangerous environment in the sense that there are flammable things in a power plant, but that's part of the nature of his job. He's there to fix things. He's a mechanic. He's working where there's coal, there's hydrogen, there's permissible leak rate of hydrogen, but he's identifying all these things and saying, I think that that's dangerous and therefore I should be protected. The law requires an actual violation. So I also want to emphasize that the idea that a reasonable good faith belief is sufficient has no textual basis whatsoever, and we've not seen any opposition to that in the briefing. And as I've noted in my briefing, the reasonable good faith belief standard comes from the Sias case in the Ninth Circuit, which basically acted, in the Ninth Circuit case, the court basically acted like a legislature and said, we think it's unfair for employees to be held to this actual violation standard, so we're going to create an exception for public policy, and that's not the way that Florida courts interpret statutes.
Do you think there's any advantage at all in the sort of continued use of any federal test standard for the statute?
I'm sorry, can you say again?
So do you think there's any advantage at all, or any point in continuing to use any sort of the federal test or standard or 3-part pronged proceedings that the lower courts have used in interpreting this particular statute?
It's the typical burden shifting framework that is applied in discrimination cases. It's also not required by the text, but Florida courts have always used it. And that's actually where the problem arose. Should
they continue to do that?
It wouldn't affect this case, but whether or not they should is, I guess, not part of this case. I'm not really sure it matters for this case. But the burden shifting framework is what Florida courts have incorporated, but they have not incorporated all of the substantive law from Title VII, which is where the Luna court sort of committed the original sin of conflating the concept that Florida courts have adopted the burden shifting framework for Title VII with the incorrect notion that they've also incorporated all of the substantive law and precedents bearing on the substantive requirements of Title VII, conflated those two concepts, and then just passively, almost without any analysis of the text whatsoever, saying, oh, because we applied the Title VII framework, we're going to apply this Title VII reasonable good faith belief standard, and that was what led us here today. The 4th District followed suit and did the same thing. So unless the court has any other questions, I've gone into my colleague's time, and we asked the court to reject the 4th District's atextual good faith reasonable belief standard and accept the 1st, 2nd, and 5th District's actual violation standard. Thank you.
May it please the court, Russell Van Sickle on behalf of Southern Company. Our interests are aligned with Gulf Power Company, and we really do not have a different argument from Gulf Power Company, so if there are no questions, we will rest on our briefing.
Thanks.
All right, my friend across the aisle used the phrase common sense, which I think is something that we need to actually look at in this context. What's the practical purpose? Why did the legislature implement the whistleblower statute in the first place? And it's to encourage reporting of workplace wrongdoing without fear of reprisal. And if we limit what an employee is protected over when they report, we basically undermine what the statute was designed to do.
Is that they chose, whether it was wise or not, they chose this to define the wrongdoing that they're protecting you from complaining about in a certain way. It's like you're just running up against a linguistic wall. That, you know what I'm saying? I mean, I'm not saying that a perfectly rational legislator wouldn't want to, gives people a little breathing room, but they wrote it the way they did.
Right, and they also wrote the Florida Civil Rights Act with the same restrictive language, but it's not interpreted that way. It's interpreted in such a way that we preserve as much of the right of access to the court system as possible for the aggrieved employee. It also uses the phrase is and makes it clear that it should be an actual violation, but the standard that's applied comes from Title VII. That's why we keep talking about Title VII, and it applies the good faith, objectively reasonable belief. If we were to put this actual violation burden on the employee, we're essentially trying to turn them into mini lawyers. If I see that something is about to go down that could potentially violate the law or be incredibly unsafe or dangerous, do I walk away, find a computer, figure out what law might apply, confirm that I'm correct, and then take this back to my employer? Has the building already burned down by the time that's happened? Has a wrong that could have been righted occurred because I was too scared that if I don't present this actual violation of law, that I would be fired and I would have no recourse?
Why isn't that an argument better directed facing that direction? Why isn't that a legislative argument?
And respectfully, it could and probably should be. It just hasn't been. Why? That I'm not sure. I think because over the years that we have just sort of fallen into a position where we have this good faith, reasonable belief versus the actual, and the trial courts are just applying whatever seems to work in that situation. And this really is the first time that we've had to sort out the issue, and we're doing it here, although there would, certainly make my life a little bit easier. But our position is that although the first, second, and fifths are now in harmony and following this White opinion, that they've taken the wrong position, and it's far too restrictive to preserve an employee's right to access the court and redress any kind of wrong that they've had. And we would ask that this court adopt the objectively reasonable standard that's set forth in all of the other discrimination laws that apply to employees, and reverse the First District's opinion in this case. Thank you.
Thank you. Okay, our next case is Synergy Equipment versus Reese, number 2024-0139.
May it please the court. My name is Michael Orr, and along with Megan Comunali, we represent the petitioner Synergy, who asks that this court reverse a portion of a final judgment entered in accordance with the jury verdict, awarding $50,000 for emotional distress damages in a tortious interference with a contract or tortious interference with an advantageous business relationship case. We have reserved 5 minutes for rebuttal. The issue that is before the court today begins with whether or not the impact rule applies to intentional torts. That is the first certified question that the 6th District certified to this court.
Michael, I'm sorry. Can I ask you a question?
Yes, sure.
Before you go into your arguments, I want to ask you a threshold question. We are in the minority of states that still have the impact, right?
Yes, Your Honor.
Is this case the correct vehicle to get rid of the impact rule altogether?
I would submit to the court that looking at other states is problematic, and I know we detailed Texas, for example, in our briefing because the FJA in their amicus brief suggested that Texas is one of those states that had abolished the impact doctrine and said we should perhaps do the same thing here, but then we don't consider the fact that in Texas, a tortious interference with an advantageous business relationship case doesn't carry with it the ability to recover emotional distress damages. That's part of the problem in looking at other states on this issue because they have a whole different body of law, a whole different body of statutes that might apply to the various claims that are at issue. Certainly, justices have written opinions in the past about their position on whether this rule should be abolished or not. In Gracie versus Eaker, in Roel versus Holt, in Abril, Justice Pariente wrote a number of opinions suggesting that the rule should be abolished. Justice Cantero, in the Abril opinion, wrote about all the issues with the application of this rule.
Talk to me about the dissent in Willis. And, you know, why shouldn't we adopt that approach? Justice Cantero outlined tell me about it, and why shouldn't we go with that?
I would submit that is not the approach that this court should take. And here's my reason why, Justice Francis. The initial underpinning of this rule from International Ocean versus Saunders, it was all about the need for a competent standard of proof, so that when plaintiffs came into the courts in the state of Florida, they had some basis to provide the jury with which to calculate or measure damages for emotional distress. And so in Saunders, when you have someone who lost his wife, was not able to be with her at the hospital, was not able to be with her at her funeral, and then had a jury award emotional distress damages for what most people would say were probably very real emotional distress damages. The Florida Supreme Court said, we're not going to permit those claims for want of competent proof. And so while I agree with Justice Cantero in the sense that the rule has been eroded with exceptions, it's been eroded with each time a case comes before this court on some new claim, like in Abril having a claim that someone breached the confidentiality required under a statute for HIV diagnoses, that the court can come back and say, well, those claims carry with them predominantly emotional damages. And in some opinions, the courts say only emotional damages.
But you just
carried.
don't think that this is a case where we finally put the nail in the coffin?
I don't, Your Honor. I think
you'd lose if we did that.
What's that, Your Honor?
You'd lose if we did that.
Most certainly, Judge. But I think the people in the state of Florida, the judges and the litigants before the courts win if this court reaffirms the rule as originally stated.
Can I follow up on what Justice Francis asked?
Yes.
Are there any, to your knowledge, any states who still retain the rule that use it for intentional torts? Or is it only in the negligence category?
My review of the law, Justice Grosshans, and this is detailed in one of the amicus briefs, is there are only a few states that still use it. But just as in Florida, there haven't been cases where courts are considering an intentional tort, which of course is why we're here, because we finally have one of those causes of action where a court...
So would you agree that if we applied it to the intentional tort, that we would be perhaps the only state that has done so?
We may be one of the only states that has been presented with the issue at the Supreme Court level.
Well, and if we did it in this case, this would be, tell me if I'm wrong, the first case in which our court has actually held that the impact rule is applicable to a cause of action for an intentional tort?
I would say...
Now, we've said a lot of things, but I'm talking about actual holding.
Yes. I would say yes and no. Yes, in the sense that there hasn't been an intentional tort cause of action that's gone up to the court, and the court has actually ruled that this intentional tort cause of action is applicable, or the impact rule is applicable to it. However, the very rule adopting the very case adopting this rule, International Ocean versus Saunders, the court did not use the word negligence. It said torts.
But it was a negligence case. It was actually a contract
case.
Contract but it was a negligent performance of a contract, I suppose,
sure,
which
right.
is, there are other problems with that. But there we get into other issues. But well, let me ask you this also. Let me ask you about Scott versus...
Scott 1 or 2?
Our Scott.
Yes.
2. I guess it would be 2.
Yes.
The 1990 Scott. And I realize we have said all kind of things. And I mean, I compliment both sides on your briefs. You've tried to work your way through all of that, and in a way that brings some coherence to what we've done. But I look at Scott, and I realize you kind of dismiss Scott. I would too, if I in your position. But I think it's a little hard to dismiss. And again, how it fits in with other things, I mean, it's kind of one of these things that's bobbing around out there. But when I look at Scott, and I realize the term impact rule is not used there, but it's certainly about emotional distress damages. That's what the certified question was about. It's about the availability. The certified question was, are damages for emotional distress available to a plaintiff in a wrongful discharge action under this particular section related to, as I recall, workers' comp claims? So that's what's at issue there. And then when we answer that question in the affirmative, they are available. But our reasoning is not expansive. I will grant that. But it does seem to undermine your position, because it says we hold that an employer who violates the statute has committed an intentional tort, thereby exposing itself to liability for damages for emotional distress. So we basically say, the only way I can read that is at least this, when the court was looking at it here, over the dissent of Justice MacDonald, pretty strong dissent. When we were looking at it here, we're saying if there's an intentional tort, there are damages for, at least the potential for damages for emotional distress. What am I missing about that?
I think that's a fair read of the case, Your Honor. Justice Kennedy, I would also say it's a statutory cause of action that the court was analyzing. They weren't addressing the impact rule. We've addressed the other issues with the case. But certainly if we're going to argue over whether or not intentional torts are going to have the impact rule applied, that should be the analysis the court's undertaking, and it didn't take in that case. And part of the problem with this case is evidenced by the 6 DCA's majority opinion. They're just looking at all these opinions and taking inferential leaps and inferences and reasonable possibilities from opinions when we don't have an opinion squarely addressing it. And
so if we were going to do our job, we'd be showing our work. So what do you think the answer is? Is this an extension of precedent that, we're kind of reading this tort reference in our previous cases really literally and kind of applying it as we would a statute? Are we looking for a principle that applies equally in tort, that implies an intentional tort, kind of like a common law principle that we're extending? Or is it kind of this policy idea that's floated around Supreme Court jurisprudence in the common law context?
That's a great question, Justice Sasso. And from our vantage point, it's really going back to the original view of the court from Saunders, where it applies across the board to torts. And we're talking about torts in general. So in the sense that if somebody had a trespass claim and a neighbor went on to another neighbor's property and stomped on their rose bushes, they would have a cause of action to get the pecuniary loss for the cost of the rose bushes. But they couldn't sue their neighbor and say, I was really upset, I was embarrassed, and I lost sleep, and by the way, give me $50,000. There has to be some competent proof. And I think if the court goes back to the original intent of the impact rule and sets forth that, one, it applies to intentional torts, it applies to all torts, and two, yes, Justice Kerr.
What I was going to say is that the trouble with that is you're certainly right that the logic behind the impact rule applies to any kind of tort, right? The central logic is that it's hard to value emotional wrong. It's hard to value emotional loss, harder at least than pecuniary. So whether I suffer such a loss because of your negligence or your intentional tort, the policy justification for the impact rule is the same. And yet, it is always associated with negligence. The restatement at Section 47 definitively links it to negligence. Our cases, by and large, I mean, you make the point that the word negligence doesn't appear in international ocean. However, there's no allegation that anyone purposefully delayed that telegram. It's clearly it's one of these weird situations where the doctrine grew up in negligence and its logic has been articulated in negligence, and yet the logic applies to intentional torts as well. No one's ever taken it there.
I would say yes and no that it grew out of negligence, because in the Saunders case, when the court was analyzing courts' opinions from other states, the court looked at intentional tort cases. They looked at seduction cases. They looked at deceit cases. They looked at other intentional tort cases where the impact rule had been applied. So this is a function of the cases that this court has considered have been negligence cases and statutory cases. I mean, a lot of these cases are where someone's claiming that, you know, they breached a confidentiality under a statute, or they had some other legal malpractice claim. And so, generally speaking, those are the causes of action that have made it here. But then you have cases like LRX from the 4th DCA in 2005 where the court essentially said you don't get emotional distress damages in a tortious interference case. So perhaps that's why this court hasn't had to deal with the issue.
So what's the rule that you're asking us to do?
The rule that I'm asking for, Your Honors, in writing the opinion. First, I would start with the first certified question in writing the opinion. Does the impact rule apply to intentional torts? The answer is yes. The second certified question, I'd actually use Judge Smith's.
All intentional torts.
Yes, Your Honor. In the second certified question, I'd use the certified question from Judge Smith in his dissent in the 6th DCA and say that it also applies to a claim of tortious interference with an advantageous business relationship or contract. And the rule should be, in the state of Florida, the impact rule applies such that you don't recover as a plaintiff for emotional distress or mental anguish damages unless you have competent, substantial proof. And I would submit this court has the ability now to say that needs to be expert witness testimony from a medical expert.
So you're saying competent, substantial proof of
the emotional distress damages, yes. And the Kentucky case that was cited in the amicus brief by FJA talks a little bit about that evidentiary standard, and that would perhaps cure some of the problems with these cases where somebody just comes into the courtroom without any before and after witness, without any documentary proof of their damages, without any expert testimony, and says, I had a rough day, I had problems sleeping, I was embarrassed, I want some money from you, the jury. The only exception should be punitive damages cases and cases in which this court has already recognized an exception. And for those reasons, we ask that this court reverse.
Good morning. We'd like to allocate 10 minutes of our time to the Florida Justice Association for their arguments on behalf of the respondent in this case. Good morning, and may it please the court. My name is Scott Adams, along with my co-counsel Ryan Labar and Kyle Mason of the Florida Justice Association. We're here on behalf of the respondent in this appeal in which the petitioner seeks to nullify a jury's verdict for its intentional and unjustified interference with Mr. Reese's employment, in which the jury awarded mental anguish damages. They seek to do that by invoking the impact rule. They made that argument to the learned trial judge, and he rejected it. They also made that argument at the 6th District Court of Appeal, and they likewise rejected it. And we're sure after here today that this court will reject it. This is because for the last 40 years, this court has precisely and succinctly stated the impact rule is before a plaintiff can recover mental anguish damages due to the negligence of another, they must prove a physical impact.
Do you agree, though, that we haven't squarely addressed this issue in the context of intentional torts, though, or do you think this is just a following precedent issue?
Our position would be, Your Honor, that the rule is, as been described, negligent. Therefore, because it's negligence, which is a reasonable, prudent person standard, that intentional torts are outside it by definition when it makes that statement. And we believe that it's clear because in 1950, this court made clear in Kirksey versus Jernigan that you could not recover psychic damages, a plaintiff could not recover psychic damages for simple negligence. It used the term simple negligence in that case. And the reason that's important is 8 years after the Kirksey decision, in the Slocum decision, this court stated that apparently Kirksey allows for mental anguish damages in intentional torts and in malicious torts. In fact, 6 years after that ruling in 1964, in LaPorte, it drew a distinction between negligence cases and those cases that are intentional and malicious, saying that basically the impact rule applies to negligent cases, not intentional tort cases.
So if the purpose of the impact rule is a proof issue, essentially, for better or worse, Florida common law for quite some time has adopted this rule of logic that because these damages are so hard to prove that in the context of negligence claims, you're not going to get emotional damages absent some impact. That rule of logic seems to apply equally across torts, including intentional torts. Why would it not apply equally in the context of intentional torts?
First, I would say, Your Honor, in this case, the quality of the evidence was never attacked at trial. The quantity of the evidence was never attacked at trial. The only issue at trial was, regardless of that, the impact rule would prevent the plaintiff in this case from recovering mental anguish damages. Now, as far as the application to intentional torts, we would disagree with the interpretation of the Saunders decision.
I'm not talking about any decision in particular. I'm just saying as a matter of logic. Why is there any difference between tort and intentional torts and applying a rule that's targeted at a standard of proof?
Sure. The logic seems to be, from the case law and just from legal precedent, that the fact that there's a higher degree of culpability in the determination of intentional torts, similar to the statutory claims such as 44205, where you see where mental anguish damages are awardable under other statutory causes of action. When there's this higher degree of culpability, the law will allow a determination of those mental anguish damages at that point.
So wouldn't that rule go more to categorically what damages are available versus matter of proof? I could see how, an intentional tort, you want to, because this isn't just like an assignment of rights and responsibilities because of accidents, essentially, this is an intentional action, that there's a broader category of damages available. But I don't see how that would differentiate the logic that this one category of damages we've said is spiritual in nature, such that we can't assess it unless there's something really palpable to give rise to the damages. And so I'm just not seeing how that would be any different in the context of intentional torts.
The proof would be, our position would be the proof would be the same in cases such as a physical impact. They say there's a physical impact, therefore you get mental anguish damages. The proof is still the same under that scenario as well. It still soars in the spiritual realm in a negligence case with an impact. It's the same with intentional tort. The reason that it gives it some credibility, and it seems that the courts are drawing a distinction. This court has consistently drawn a distinction when there's an impact, right? Under Saunders, it lists the 3 opportunities for recovery as it synthesizes the cases. And our position would be the Saunders decision does recognize intentional torts as recoverable. And we would say that because if you read closely the analysis in that case, what the court does is it says the Texas rule, which allows it in any case. It then attacks that and attacks those cases. And then it lists 3 cases, 2 from England and 1 from the Supreme Court of Michigan, the Tribune Company versus MacArthur case. And it even quotes the language there. It says an intentional act, or not an intentional act, a voluntary act, and an act of very gross neglect. And if you look at the underlying opinion in that case, it says mental anguish damages are recoverable for a voluntary act and for a very gross neglect situation. So from the foundation of this court's precedent, the common law has always been that if there is an intentional tort, you get mental anguish damages. That was revealed in the...
Could I ask you, is it your position that just sort of everything is available? Like if there's no victim impact rule of application to intentional torts and they're going to argue mental anguish, that it's sort of everything is on the table, they can argue whatever they want in any type of case? Or do you think there should be any parameters? Should there be a foreseeability factor? Should there be reasonableness? Should there be any sort of those types? Should there be expert testimony required? Is there any guardrails, or is it just anything can go to the jury?
Sure, Your Honor.
Not foreseeable, not anything.
It would be the basic tort principles of foreseeability would be applicable.
So you would think all of those same principles still apply?
Yes, Your Honor. Yes, that would be applied. Now, to be clear, our position is not advocating for the jettison of the impact rule, as this court has stated, while it's well within its rights to do that. All we're simply saying is that the impact rule, as stated by this court, applies to negligent cases. The trial judge accurately applied that rule in this case, and the 6th District Court of Appeal clearly stated what the rule is. It did not plow any new ground in its decision below. It simply looked at the cases in which this court has stated and pruned its decision, such as the case of Kirksey, such as the case of Slocum, such as LaPorte, such as Scott 2, and the underlying district courts of appeal cases where they clearly state that the impact rule does not apply to intentional torts. It just overtly stated that in this case, firmly consistent with the cases that this court has had. Now, if the court, and for those reasons, we would request that this court answer that first certified question. Is the impact rule an exclusion, or excuse me, is intentional torts an exclusion to the impact rule? We would answer that question in the affirmative in this case. Now, if the court didn't want to go that far in rule, we would argue, as the 6th District Court of Appeal found in this case, that tortious interference with an at-will contract or an advantageous business relationship is an exception to the impact rule under the freestanding tort exception that this court recognized in Cush. And a freestanding tort, by definition, is one that has an independent basis of liability, and that the damages are distinct from mental anguish or parasitic. The mental anguish damages are parasitic. That's the scenario that you have in this case. That's the rule that the District Court of Appeal applied in this case, well within this court's precedent. We have an independent basis of liability in this case, the intentional tort of tortious interference with an advantageous business relationship or at-will contract. And the damages of mental anguish are in addition to the economic damages that were awarded in this case. So I would request that this court answer that second certified question, that tortious interference with an advantageous business relationship is an exception. Intentional torts are exclusions, as identified by this court in a Rowell versus Holt decision at footnote 1 and recognized in the April decision from this court. And then finally, we would argue that if the court didn't want to rule that far and wanted to rule narrowly, that it could find malice in this case. And we would say there would be one of three rubrics the court could use, or three different rubrics. First, the court could hold, as the 6th District Court of Appeal did, that actual malice is present under the facts of this case.
Did the jury find that, though? Was that a jury finding?
We would argue, Your Honor, under...
Was the jury instructed on malice?
It was not in the instructions.
So it was not in the instruction. So how do we know that the jury concluded that there was malice? From what would we draw this assumption?
Sure. Under the 4th District Court of Appeals decision in Hercello, in cases of tortious interference cases, they concluded there that actual malice can be determined in one or two ways, either by proof of ill will or spite, or, in these types of cases, by improper means being utilized. That was an example.
And who is supposed to make that finding?
The jury.
Court in the first instance?
The jury can make that finding.
Okay.
And in fact,
the jury did not make that finding below. Right?
At the trial court and the jury made that finding, yes, Your Honor.
Okay.
The jury made the finding that what was at issue at trial, the judge ruled summary judgment that an intentional act had occurred, right? The intentional part of it. The issue then was, is it justified? And the issue then became, was it proper means used for the interference? The jury found no proper means for the interference. Our position is that improper means under the Hercello decision is a matter in which to find actual malice under that decision, one of the ways. And now we would also...
You're eating in your colleague's time. I don't know if you want to...
And I'll wrap it up, Your Honor. Therefore, we would request that you answer the first certified question in the affirmative, that intentional torts are exclusions to the impact rule. 2, that the tortious interference with an advantageous business relationship or at-will contract is a exception to the impact rule, and that actual malice is present in this case. Therefore, under the facts of this case, it is an exception. Therefore, we'd ask this court to affirm the 6th District Court of Appeals opinion in this case, and to the degree that it is any conflict with the Reed decision, that you quash that decision. Thank you, Your Honor.
Thank you.
May it please the court, Kyle Mason on behalf of Amicus Florida Justice Association. Your Honors, the question before the court today is whether Florida should become a minority of one by being the first state to expand the impact rule to encompass intentional torts. I respectfully submit that the court should not do so because it's contrary to the vast weight of American jurisprudence on this issue and to the rationales that underlie the impact rule.
We're kind of already there. I mean, we're already in the minority in having an impact rule in general. Correct.
That is absolutely correct, Your Honor. But
so I guess what do you see us doing? Are we cabining what was kind of initial error, or do you see this as truly something distinguishable from as a matter of logic in the negligence context versus an intentional tort context?
So, Your Honor, I do think it is distinguishable between the negligence, and for several reasons, which the other courts that have addressed this issue have discussed. First, intentional torts serve the similar purpose as physical impacts, and in that it authenticates that a real legal injury has actually occurred. That's different from a negligence context. When you have a negligence without a physical impact, which happens all the time, every time we speed on the highway, that's negligence. There is a potential for some sort of unmoored emotional distress, but there's really no other cognizable legal interest at stake. So when you have an intentional tort, you know that the plaintiff has suffered an actual injury because there has been an infringement on some legally cognizable injury, interest, whether that is the right to an advantageous business relationship, or whether that's right to be free from insult.
Don't you have to concede if the focus is on the logic of the difficulty of proof, there's no difference. But it seems like the reason for the impact rule is it's not saying that emotional distress damages are not a real thing. I think it's just based on the idea that given in the negligence realm, the law is going to sort of err on the side of not subjecting the negligent party to such speculative damages. And I think it seems like the reason why you would distinguish the intentional torts is that even though you acknowledge that the proof problems are the same, that essentially when the party is kind of culpable in this different way, in this, intentional wrongdoing, it's like we're going to, in the negligence context, the claimant is the one who sort of bears the risk of the rule sort of being over-inclusive, and in the intentional tort context, you shift the possibility of getting it wrong onto the intentional wrongdoer. I mean, it seems like that would be the basis for the distinction. It can't really be the difficulty, the speculativeness of the harm or whatever. That's kind of the same.
I would largely agree with that, Your Honor. It's definitely one of the reasons to distinguish this is moral culpability in intentional torts are just much higher. It's a moral.
Well, and it's what is the law? If you assume that this is a real, in reality, that it is a possible harm, and you're sort of taking it off the table or leaving it on the table, you could imagine that a reasonable sort of distinction for where you would leave it on the table is when someone did something intentionally wrong, and you would take it off the table when they were merely negligent. I mean,
that's exactly right, Your Honor. I completely agree. I would also add that in terms of just pure foreseeability, intentional torts, it's more foreseeable that there's going to be harms, potentially including even emotional and mental distress, just because when you intend to cause somebody harm, you tend to cause more harm than a negligence claim in just a similar context. So I would agree that there are policy reasons, rationales based on just the moral, the wrongdoing, however we want to phrase a distinction, and just foreseeability, and also that it serves intentional torts serve an authentication purpose, the same authentication purpose that physical impacts do.
Well, I don't think that's really. I mean, that to me is not. It doesn't matter, but I don't think that's not persuasive.
So can I ask you about next question? No.
I'd go with that.
One of the concerns I have is that we're being asked, because of the conflict, and I understand what was presented to the 6DCA, and they were kind of constrained. The conflict is presented as this very broad rule, but there seems to be this issue floating out there about whether this category of damages is available in this cause of action at all. Do you see any issue with kind of leaving that unaddressed? Is that going to create issues down the road if we've announced this rule that impact rule is not available or does not apply to intentional torts? But then there's still this question of whether emotional damages are available as a category of damages, depending on the cause of action.
So, Your Honor, and please feel free to correct me if I misunderstood the question, but I would believe that if we answer, say, the first certified question in the sense that the impact rule does not apply to intentional torts, then proving mental and emotional damages in intentional tort cases would be, as my colleague said, much the same as proving in a physical impact tort. You would present evidence. If the court wished to address the sufficiency of that might be an issue in another case. It was not. Yeah,
I'm not so much talking about sufficiency. I think it was the 4th DCA case that says you can't get emotional damages and intentional interference with the advantageous business relationship. Anyway, there's district court cases suggesting that this category of damages is not available.
That could be just a rule of law that's totally independent of the impact rule.
Correct. And so my concern is that we announce this broad rule about applicability of impact rule to intentional torts, and then there's these ancillary issues in the cause of action that's presented in this case about whether that category of damages is even available.
Right.
Do you see that as a concern, or do you think the addressing one rule kind of takes care of the
I don't think it's a concern, Your Honor, but principally because if this court does have those ancillary concerns, it can simply state in its opinion that we're just simply deciding the scope of the impact rule, and that broadly speaking it does not apply intentional torts and nothing else is raised, so we're going to affirm. If the court wants to limit its opinion in that matter, the court can do so. Whether as a matter of logic there can be emotional or mental damages in these claims for intentional interference with a business relationship or a contract, that might be best briefed in another case where it could be the focus of the briefing. So that's where I would draw the distinction. I don't think it would be a concern that would prevent the court from accurately stating the scope of the impact rule as it has been presented by the briefing and by the certified questions. With that, Your Honor, Your Honors, I would simply add just briefly that this exact issue has been addressed by the other state Supreme Courts directly. It was directly addressed by the Indiana Supreme Court, which is another impact rule state in Collison. It was directly addressed by the Georgia Supreme Court in a line of decisions, tracing all the way back to its Chapman decision, which this court relied on in 1893 when it adopted the impact rule. And that the law, American jurisprudence, Florida jurisprudence on this is just exceptionally clear. Impact rule does not apply to intentional torts. And for that reason, the court should affirm the judgment of the 6th District. And unless the court has any further questions for me,
Thank you.
May it please the court, I would simply address 2 points on rebuttal. First being that in writing its opinion, this court should address the freestanding tort doctrine. When the court used that terminology for the first time in Cush versus Lloyd in 1992, it didn't define that term. In the 6th DCA's majority opinion, it's the first time we see a definition for it. And I think Judge Smith, in his dissent, does a very good job pointing out that using that definition would lead to every tort falling within the definition. The second thing that I'd like to address is what my friend from the FJA, on behalf of the FJA, just submitted to the court, which was that the court could write its opinion essentially finding that the impact rule doesn't apply to any intentional torts, but then not address whether or not emotional distress damages are even recoverable in the first place with this cause of action. I submit that would be yet another case in a long line of cases involving the impact rule, creating more confusion. The litigants argued below over LRX and whether emotional distress damages were recoverable in these cases. And just like Texas, if we want to look to other states, parties shouldn't be able to recover emotional distress because they were really upset that their contract was breached, or they were really upset that their business case fell through. This court should absolutely address that issue in its opinion of whether emotional distress damages are even recoverable in these types of cases.
But that's partly kind of a prudential thing for the court. I mean, there's the certified question about the impact rule and intentional torts, and then there's this particular thing. And I don't know that it would, quote unquote, create confusion. It would just kind of leave for another day this sort of more discrete issue about this particular cause of action and what damages could or couldn't be recovered. And the arguments would just, in that later case, they would just be not about the impact rule anymore. There would have to be some other reason why the party that didn't want them to be available would have to persuade whoever the decider is that they wouldn't be.
Certainly it would depend on how the opinion's crafted by this court, but I would actually disagree with Your Honor on that point. If an opinion comes out and it only addresses those certified questions and says, does the impact rule apply to intentional torts? And if so, does the impact rule apply to the cause of action for tortious interference with an advantageous business relationship? And this court only answers those questions and says, no, it doesn't apply to intentional torts. No, it doesn't apply to this cause of action. Then what we're left with is an opinion that lawyers and judges around the state will look to and say, well, there was that cause of action that I'm dealing with in my case, and the court upheld a jury verdict for emotional distress damages. What am I left to do at that point?
Well, of course, the questions we answer are up to us.
Absolutely.
And we don't have to answer the questions that the district court has certified. We could answer just the first question. We could just answer the question about whether the impact rule applies to intentional torts. And if we decided it adverse to you, then that would be that. And then these other things would be for another day, right?
I agree, but I still would submit. I still would submit we'd have the same problem that we had in this case, where the trial judge, the reason the trial judge ruled the way he did, is he looked and he saw the Abril opinion where the court made the statement that the impact rule does not apply to any intentional torts, and that issue is very well set forth in the briefing and the opinion from the 6th DCA, where they point out that the support for that statement by the court doesn't exist. When they go to the Roel versus Holt case in the footnote 1 of that opinion, it says that the rule doesn't apply to certain recognized intentional torts in a very narrow subset of cases. Justice Lavarga. Did you look like you were about to ask a question?
You're just making me think.
Could I ask you
Yes.
to do one thing? I was making a note and I didn't quite catch it all. When you were answering Justice Francis's question about, I think it was her question about what the opinion would look like.
Yes.
Can you answer that one more time for me?
Absolutely. So the way that we would suggest the opinion be written is start by setting forth the certified questions, and we would do so by using the first certified question from the majority opinion in the Reese
And you would
case.
say the victim
And then the second certified question from Judge Smith's dissent, and we would answer in the affirmative that it applies to intentional tort cases, and in the affirmative that the impact rule applies to the tortious interference
So what you said
with
about
advantageous.
unless there's substantial proof, that
Well, what I was suggesting, Your Honor, and very good, after answering these questions in the analysis that the court sets forth, I would suggest that the principles that should be addressed in this opinion, one, are the proof issue that the court addressed in Saunders, and two, this freestanding tort issue that came up in Cush versus Lloyd. And for those reasons, we ask that the court reverse the trial court's denial of the directed verdict motions that were filed by Synergy. And thank you, court, for the time.
Thank you. We'll be in recess for 10 minutes.
We would have had like a whole crew, but it was that long drive. We were like, should we bring 10 people? Because we may not do another case. That's right.
Now we can say we did.
That's right. That's right.
Hey, good luck on the leading the bar.
I appreciate it. We're gonna need a lot of help. If you guys have people that want to get involved in some committees, there's going to be in the next bar news an announcement about that, and the deadline for filing is December 15th. I'd love to get.
Yeah, I'm on the wage and hour, and the guy who's head of the wage and hour, he's already called us. We already had a meeting.
Awesome.
So we're already involved to some degree.
If you've got more lawyers that want to go to the front, get people on and say, let's position them going, all right, you practice health law, and you want to be on something. We don't even do that. It's like, because somebody told you you could get on that committee.
Called in a favor, too.
That's right. That's right.
One water. I apologize. One water. Hold it over there. I'm gonna hold it up like this. Don't drop anything on the floor. Need one water. Don't pick it up. Don't worry about it. Cause your hand will be on it. I need 2 waters.
I need one water. I need one water. Yes, sir. And you can take back Brian. Brian, is that? Put your cooler back on the bottom. And all the used water, lay them up top there. So you can throw them away. Thank you.
All rise. Supreme Court of Florida is now in session. Please be seated.
Okay, our third and final case for today is McDowell versus State of Florida, number 2024-1148.
May it please the court, counsel. Good morning. In this capital case, Mr. McDowell is appealing from his sentence of death following the conclusion of his penalty phase in 2024, which ended in an 11-1 death verdict. We've raised several issues on appeal, but as this court's aware, the first two of these are already pending before this court, those involving the retroactivity of the 2023 amendment to the capital sentencing statute and the challenge to its lack of unanimity. So because those are pending in other cases, as we pointed out in the initial brief, and have been extensively briefed and argued already, I'd like to focus primarily today on the next point up, which is point 3, which deals with the victim impact evidence.
I'm sorry, you speak up just a little bit. I can barely hear.
I'd be happy to.
And I'm pretty good at hearing.
So the elephant in the room with victim impact evidence is this court's decision in Wyndham v. State. Now, I think it's worth noting that that decision was in 1995 under a different version of our capital sentencing statute, but it dealt with essentially the same argument. It's also worth noting that at the time, Florida's capital sentencing statute attributed a significantly less importance to the jury's recommendation. It didn't require a unanimous finding that any of the aggravators have been proven beyond a reasonable doubt, for instance. It didn't confine the jury to considering just those unanimously found aggravators. The recommendation was a simple majority, and I think maybe most importantly, the jury's recommendation of life was not binding on the trial court. We still had death overrides back then. But either because or for that reason and because of the merits of the underlying argument, we're respectfully requesting this court reconsider that issue. And the issue stems primarily from a conflict within our capital sentencing statute between paragraphs 2 and 8. Paragraph 2, which exclusively governs the jury's deliberations, sets out specifically what the jury can consider, which is limited exclusively to the aggravators that are found beyond a reasonable doubt and the mitigators that the jury believes to exist. Section 8, on the other hand, is bolted onto the end of the statute and permits the state to introduce victim impact evidence in a capital case. The problem, of course, is that victim impact evidence is neither an aggravating circumstance nor a mitigating circumstance. It's not among the things that the jury's deliberations are exclusively cabined to. And so because of that, we just have this prejudicial influence from a factor the jury can't consider. And the remedy that has come up has just been an instruction. The jury's instructed that they can't give aggravating weight to this evidence, that it's only being introduced for the purpose of demonstrating the uniqueness of the individual. But again, the uniqueness of the individual isn't something that's relevant to the jury's deliberations. They're expressly prohibited from considering anything other than the unanimously found aggravators and weighing those against the mitigators. This evidence, I think it's important to point out, is also always in every case going to be prejudicial to the defendant, and it's always in every case going to be at least somewhat impactful. It's not negligible. And I think the record in this case demonstrates the kind of the worst case scenario of what that looks like, where you have sobbing members of both the members of the public in the courtroom as well as members on the jury. This is the problem is injecting this kind of prejudice into the proceedings distracts the jury from what should be the focus, which is just what they're confined to determining, whether a death is appropriate based on weighing the aggravators against the mitigators.
So if we accepted your argument, what would be the basis for it? What are we going to cite? And what do you cite as the basis for deciding in your favor on this issue?
So the prejudice it's an Eighth Amendment prejudice because the presence of this undue factor creates the...
But okay, has the Supreme Court ever, U.S. Supreme Court ever said that? Or what's the U.S. Supreme Court said about this kind of evidence?
What they have said is that the jury's focus needs to be, or that anything that's going to distract the jury from...
What have they said about victim impact evidence?
Oh, well, so in Payne v. Tennessee, and I don't dispute that Payne v. Tennessee, or we're not trying to relitigate Payne v. Tennessee, but in Payne v. Tennessee, the United States Supreme Court held that the Eighth Amendment erects no per se bar to the introduction of this evidence. So we acknowledge Payne v. Tennessee, and we don't think that if this court agreed with us that holding would be in conflict with Payne v. Tennessee, because the issue isn't that there is a categorical bar on this evidence. The issue stems specifically from Florida's system, which is cabining the jury to not consider this evidence and then presenting it to them anyway. If Florida's sentencing...
But our system, those are elements. Both are elements in our system. I'm kind of lost, because if the Supreme Court says it's okay, I'm struggling to see how there's a pathway through here for us if if there happened to be agreement with you, because I just don't see it.
Well, because it's not about the nature of the evidence. So this issue involves victim impact evidence, but it could be any other kind of prejudicial evidence that is not an aggravating circumstance or a mitigating circumstance. So the fact that Payne v. Tennessee said it's...
Part of the problem here is that Florida law specifically contemplates the presentation of victim impact evidence.
Yes.
And so it's not, you can't say it's in conflict with our statutory scheme. You may think there's tension between different elements of the scheme, but the scheme is the scheme, okay?
Yes.
And if the Supreme Court says it's okay, I'm struggling for any hook.
Well, I think it's important to distinguish those two things, because I agree that the scheme is the scheme. I agree that both of these things are present in the scheme. Our argument is that they're internally inconsistent, that if paragraph 2 is exclusively governing these deliberations, and they're limiting them to the aggravators found beyond a reasonable doubt and the mitigators, and victim impact evidence is neither of those things, then it is an irrelevant factor that's being injected into that proceeding. So that the United States Supreme Court has held that if a state wants to determine that victim impact is appropriate for a capital sentencing jury to consider, the Eighth Amendment's not going to prohibit it. That doesn't foreclose this argument here, because you still just have this prejudicial influence. It is just as improper as an improper closing argument, or as irrelevant evidence, or as an invalid aggravating factor being presented to the jury. It is beyond the scope of what the jury ought to be considering. And because of how prejudicial and powerful this evidence often is, as the record in this case demonstrates, it creates that risk of undue influence. So
does your argument kind of necessarily depend on the jurors not following the instruction?
So the problem is that even the best instruction can't fix a bad statute, right? So a juror, first of all, I don't think it's even possible to ignore this type of evidence. It's, again, if it's resulting in jurors and members of the public in the court bursting into tears, it's just, an instruction is not going to, there's some bells you can't unring. We can't present this evidence to the jury and then proceed on the polite fiction that it isn't actually influencing them because we told them not to consider it. I think it's also worth noting out that this has to be incredibly confusing for the jury itself, because throughout this process, everything that's being presented to them is gatekept by its relevance to their ultimate determination. And then here they are at the end of the proceedings, after both the state and defense had presented their case, and they're told, well, now we're going to present you with additional evidence, but you can't consider it. And then they immediately go back to deliberate. And so injecting that kind of prejudice into these proceedings is what renders the system or what creates this risk of arbitrary and capricious action, because you're now having this very emotional thing that's presented to the jury. And this was the underlying argument in Booth, but it exists here because the jury is prohibited from considering it. At the time of Payne, they were prohibited from considering it under Booth, but today they're still prohibited from considering it by the text of the statute. That's why the standard jury instruction is there and explicitly prohibits the jury from considering this evidence. So I don't think it does much good to say, well, they're instructed not to consider it, because even, as we pointed out in the initial brief, even judges have difficulty not being affected by this, so that they recount being haunted by this evidence months later. So I think as trial counsel put it below, there's no human way possible to ignore just how impactful this evidence is. I mean, it is, and understandably so, right? I mean, this is among the most devastating emotional kind of thing that you can consider.
Do you want to address, speaking of confusing the jury, address the harmless error argument, especially in light of the kind of invitation of the death penalty?
Yes, Your Honor. So I'd say there's kind of two reasons why it shouldn't be considered harmless. The first is that this kind of error is, we believe, structural. So because the prejudice is in one form, the product or the resulting arbitrary and capricious imposition of the death penalty across all cases within the system. But even if we're limiting it to just this case, I think there's a few good reasons to not find this error to not find this harmless, or to rather to hold that the state has not proven beyond a reasonable doubt that this is harmless. The first is that this was an 11-to-1 death wreck, right? So while we can't get into the minds of each individual juror, we can't know what their decision-making process was. We know at the very least that at least one reasonable person viewed the mitigating evidence as significant enough to vote for life instead of death. I think at the second part of that is that, as I was mentioning earlier, victim impact evidence is something that is inherently compelling, right? It's inherently impactful, and it can't be considered negligible. And because it is also always going to be prejudicial to the defendant, we know that it moves the needle a little bit. And what we don't know is whether or not this evidence is what pushed a few of these jurors over the line from wanting to recommend life to recommending death.
But am I right that the penalty phase happened after the new law went into effect?
Yes.
So, I mean, from a harmless error standpoint, wouldn't you have to show not that it pushed a few, but that indeed it was dispositive to the sort of death majority? I mean, it seems like, to the extent you're making an argument, the timing of this argument, the timing of the penalty phase matters, because it isn't the same as if unanimity were required. Do you concede that, I guess I should say?
I don't believe so, Your Honor. And I hope that's not indicating how you're moving on points 1 and 2. But setting those aside, I think the question is just whether any reasonable juror would be moved from life to death by this evidence. Okay. Because we can't, there's no way of knowing if it's 1, 2, 3, 4, or all of them. If the reasonable possibility exists for a reasonable juror, then it's just as reasonable to expect that it's more than one. So I would not concede that it's that the number here is at play. If it were a unanimous death rec, I think that argument is a lot harder for me.
Right.
But because we have the 1, I think that means that it is at very least a close call, right? It means that it is not the aggravators cannot be presumed to be so aggravating that they outweigh the mitigator in every case. So with that, I'll reserve.
I'm sorry to interrupt you.
Yes.
Could you remind me again, what does the standard jury instruction say about the victim impact evidence?
It says that the jury cannot give, you're about to hear victim impact evidence or statements from the victim's family about the resulting loss to the community, and that they cannot give that evidence aggravating weight, that is being introduced solely to demonstrate the uniqueness of the individual and the resulting loss of the community from their death.
Okay. So, I mean, to the extent that your argument, though, is about the statutory scheme, I mean, it seems like for what you're saying, for it to be kind of irrational or kind of unavoidably contradictory, you basically have to read the subsection 2 stuff as if it's kind of a negative implication thing, like this is the only, like I understand that things can only be considered in aggravation that are the aggravating factors, but it basically says, you know, based on your consideration of the aggravators and the mitigators, this, but it doesn't say, I mean, when you have a later section that says you can hear this evidence, it's not saying, as long as your recommendation is based on that, it's not on its face precluding you from factoring in whatever way you think it's relevant, the victim impact evidence.
Well, respectfully, Your Honor, I would disagree. I think it is pretty clear from the text of the statute, because they're referring to aggravating circumstances, which are an enumerated list. They're finite. There's a set number of aggravating circumstances. And we know that this type of evidence can only be prejudicial to the defendant. It can only be aggravating. It certainly isn't mitigating evidence, right? So it's definitely not qualifying as mitigating evidence. If the only thing left is the aggravating circumstances are an enumerated list that are clearly defined, then it's just outside of it. I mean, the problem is that this is just a poorly constructed statute. It's not.
So what would you, how would you fit, if you, assuming that victim impact evidence is constitutionally permissible, and assuming you have a legislature that wants it,
right,
to be part of the process, how would you fix the statute?
The easy solution is just to present this evidence in Spencer. If this evidence is presented at the Spencer hearing, I think we can rationally assume that judges are going to be better capable of withstanding the emotional impact of this than a lay jury would. And in the instance of if the penalty phase results in a life recommendation, then you could have this presented at sentencing prior to the pronouncement of sentence, right? So it would still account for the state and victims' families' interest in speaking publicly in the case during the sentencing process, but it without compromising the jury's deliberations or infecting the jury's.
But it's not constitutionally impermissible for the jury to hear it and consider it.
No, Your Honor.
Okay, I'm just curious what your fix is that doesn't essentially take the jury out of the equation.
Well, you're saying that it's not constitutionally impermissible for the jury to hear it. I agree with that.
Okay, so and the legislature wants them to hear it. So
yes.
Telling me that you can do a dispenser hearing doesn't solve that problem, right? Obviously.
I think the language of the Article 1, Section 16 and the language of paragraph 8 both contemplate presenting this evidence to the jury. I think that goes, if it's prior to their deliberations, I think that goes too far. I do think it would be appropriate, and I think it's a rational compromise to have this evidence presented to, if it's presented to the judge, then it's at least being considered by the sentencer. If it's presented at the sentencing hearing, at least the public and the jury is still hearing it. It's also maybe worth noting that the statute doesn't require that they be presented with this evidence prior to their determination of whether to recommend life or death. So that's another way in which you can avoid this kind of conflict here. But where there is that conflict, I don't think that the state's interest in presenting this evidence at the sentencing hearing or a third party's interest in speaking at a defendant's sentencing hearing can override what ought to be the heightened protections in a capital case of their right to have the determination fairly decided based on the text of the statute and what they're required and prohibited from considering. So with that, I'll reserve the remainder of my time.
Good morning, Your Honors. May it please the Court, my name is Jonathan Tannen for the Attorney General's Office representing the state of Florida. The state is asking this Court to affirm the conviction for first-degree murder and sentence of death for the murder of Deputy Joshua Moyers. With respect to victim impact evidence, this question has been settled by the United States Supreme Court in Payne versus Tennessee, which held that the admission of victim impact evidence does not violate the Eighth Amendment. As the Supreme Court explained in Payne, the purpose of this evidence and the reason the state has a legitimate interest in presenting the evidence is to remind the sentencer that just as the murderer should be considered as an individual, so too the victim is an individual whose death represents a unique loss to society and to his family in particular. And the purpose of that evidence is so that the victim is not treated as, in the Supreme Court's words, a faceless stranger at the penalty phase of a capital trial, that the jury understands this was a real human being whose death caused real harm not only to that person, but also to their family and their community. And this court, of course, is bound by the Supreme Court's ruling in Payne. And
could you address, I'm sorry to interrupt you, but could you address what because everything you just said is obviously true, but could you just address, like, what's your answer to what he's saying about the sort of, what tensions, inconsistencies, illogic, whatever you want to call it, about the way it's just set out here in the statutory scheme?
Well, I don't believe there is any tension in the statutory scheme, Your Honor. The purpose of the evidence is not as aggravation or mitigation. It's so that the jury understands the significance of the murder and the fact that the victim is effectively a real human being. And that sounds like a very simple point, but as the Supreme Court discussed in Payne, in the capital sentencing proceeding in a capital trial, the defendant has the right to present extensive evidence about their personal history, their background, and to have that considered as mitigation. And especially in a case like this, where the defendant presents very significant mitigation about their personal history, lengthy mitigation presentation.
I'm sorry to interrupt you, but his point is, I think he's saying that there's just textually, there's just a problem with, if you read this as kind of a negative implication situation, it says, based on the considerations in subparagraphs A and B, i.e. the aggravators and the mitigators, whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. And then it says, you're also going to hear this other stuff. So I think, I'm just curious, does this mean, should this be read literally, that the recommendation is only supposed to be based on the consideration of those things? In which case, it is weird then, why are you hearing anything else? Or is there a way to make it all fit together?
Well, that's everything you've said is correct, Your Honor, but the legislature has told us what why the jury is hearing that evidence.
So it's not relevant to their recommendation?
I believe it is relevant to their recommendation. It's relevant so that the jury understands the harm caused by the crime of first-degree murder and by the loss of the victim. I think that's something inherent in the crime itself, not necessarily aggravation or mitigation. It's so that the jury understands why it's there to begin with and doesn't simply, write off the fact that there is a victim in this case as, treating the victim as essentially a name on a piece of paper or, again, a faceless stranger, to use the Supreme Court's words. And the legislature has told us what the purpose of it is. It's so that it's to demonstrate the victim's uniqueness as an individual human being and the resultant loss to the community's members by the victim's death. That's not necessarily aggravation or mitigation, but it is something the jury should keep in mind in understanding why it's there and the magnitude of its decision.
In a penalty phase, there's a lot of focus on the offender as a person. I mean, that mitigation is all about that. Aggravation is its own category, particular things enumerated. But I think what you can understand the legislature trying to do is you've got all this focus on and this just, I'm just repeating what I think you've already said. You've got all this focus on the defendant as a person, and that in that mix there should be some focus on the victim as a person, and that should not be lost sight of. Not that anything about the victim is going to be aggravating, but that reality is worthy of recognition and acknowledgement in this process.
That's correct, Your Honor. And the Supreme Court talked about that in Payne. In the sentencing proceedings, the defendant is entitled to present extensive mitigation, and the purpose of that mitigation, in large part, is to convince the jury that the defendant is not just the crime they committed. They're a three-dimensional human being, and every aspect of their life and character should be considered. And of course, at the trial, at the penalty phase, the defendant is there and can sit in front of the jury. That's not true of the victim. If, without victim impact evidence, all the jury ever hears about the victim is that they were a person who was killed by the defendant. And this is what the Supreme Court explains in Payne. It's important, and the state has a legitimate interest in reminding the jury that this isn't just a name on a piece of paper, this isn't just a faceless stranger, this was someone who suffered real harm, and their family and community suffered real harm as a result of their death, and to treat them as a human being and not an abstraction. I would add as well that the court recently discussed this issue in Fletcher in a decision just issued this July, and pointed out that in addition to being bound by Payne, the Florida Constitution itself mandates the admission and consideration of victim impact evidence. Article 1, Section 16 states that the victim and the victim's family have the right to present victim impact evidence and to have that evidence considered in support of any sentencing recommendation. And this court pointed out in Payne that in light of that provision, the court is constitutionally prohibited from granting, in that case, Fletcher's request to have victim impact evidence declared unconstitutional. I would just address Mr. McDowell's counsel's point as far as the impactful nature of the victim impact evidence in this case. I believe the argument is solely that victim impact evidence itself is unconstitutional. The defense did not object in this case to any of the victim impact statements before they were read, and the defense did move for a mistrial based on the allegedly emotional reactions by some jurors to the victim impact evidence. The trial court ruled that the behavior of the jurors was appropriate. It determines that a mistrial was not warranted under the circumstances of this case, and that decision has not been challenged in the initial brief. So the sole issue before this court is whether victim impact evidence is unconstitutional, and that issue is controlled both by Payne and by the text of the Florida Constitution. Does the court have any additional questions about this issue or any of the other issues in the case? In that case, I will rely on the state's answer brief for any further points and requests, again, that this court affirm the conviction and sentence. Thank you, Your Honors.
Thank you.
So just a few points in rebuttal. First, as opposing counsel pointed out, the United States Supreme Court in Payne did mention what the relevance of this information, of this type of evidence was. And I agree that it's relevant in the abstract. The issue is whether it's relevant in Florida's system and whether it is whether it's appropriate for the jury to consider it or whether it's outside of the scope of their deliberations. And we think it is based on the text of the statute, based on the fact that the jury is admonished to not consider this in a standard jury instruction, and because it simply isn't an aggravating factor.
I mean, but just to be fair, I mean, it's the instruction I thought you said is that it can't be considered as an aggravator, right?
Correct.
And so that's kind of a term of art, as meaning that can't be sort of the basis for making you eligible, and then that's going to be weighed. I mean, it's not. I mean, it seems like the jury's hearing all kinds of stuff. And the things that they hear, they don't necessarily have to fit in logically into being labeled either an aggravator or quote unquote mitigation. I understand. I think textually it is interesting. It is weird to say you can hear A, B, and C, but then based on A and B make your recommendation. That is, I mean, so that's almost more of like a drafting type problem than injecting some inherent kind of unfairness to the point of unconstitutionality into the process.
So, well, a few points. One, I think the logic that you just described about why, well, the jury's hearing all sorts of things, not all of them are inherently, tied intimately to the aggravator. Why is this a big deal? I think that argument would make a lot of sense in a system where we had a catch-all aggravator that involved the circumstances of the crime. I could see an interpretation of victim impact evidence falling under a broad catch-all kind of
But I don't know,
aggravator.
but that wouldn't, I mean, in terms of the legal purpose that aggravators serve, I don't know if you could ever have, I don't think you could, if the point is to narrow the class of people who are eligible, if that's the legal work that aggravators are doing, I don't know if you could say, aggravator number 14 is, do you unanimously agree beyond a reasonable doubt that there's some other unspecified thing that makes this person eligible for the death penalty? I mean, that's kind of not what I mean, I don't need to tell you.
Well, it depends. So I think you're right, but it depends on. So it's just when states are constructing a capital sentencing statute, there's two general parts to it. There's the eligibility phase, which is what you're talking about when you mention, well, this is just kind of the initial threshold thing that needs to be met, and you can't have something too broad, otherwise all offenses would qualify. But other states also have, when they get to the weighing stage, because there are jurisdictions that are considered weighing states, others that are considered non-weighing states, and Florida is a weighing state. Florida has a set number of aggravators, and the jury is not permitted to consider anything other than those aggravators. In a non-weighing state, which is what I was referring to, you could have a situation where the jury is permitted to consider in the selection phase, which is basically at the conclusion of penalty when they're determining whether to impose life or death, the jury can consider any other aspects of the crime. But we don't have that system in Florida, and I think that's what distinguishes this from the logic that you're providing, which would make sense in the abstract, but not here. And again, this is just resulting from the fact that Florida statute cabins the decision-making exclusively to the aggravators and the mitigators. I think it's also, as we mentioned earlier, victim impact evidence can still be presented at the sentencing hearing before the pronouncement of sentence, or to the judge in the event of a death recommendation. It could be presented at the Spencer hearing. So there's nothing that would the victim's family's interest in presenting this evidence. You wouldn't be violating their right to present this at sentencing if it's occurring during the sentencing hearing. And for the same reason, in the non-capital context, if you had a case, for instance, that had a minimum mandatory, let's say their PRR, and they're going to get 30 years no matter what, it doesn't violate the Article 1, Section 16 for the jury to speak at sentencing about the way that the loss has impacted them, or the victim to speak at sentencing about how the offense impacted them, because the sentence is just as already decided in that case as it would be in the case of a life recommendation. So I think the compromise here is just to either present this after deliberation, or to present this after deliberations, and whether that be before the pronouncement of sentence or at Spencer, I think that fixes the real problem here, which is the impact on the jury's ultimate determination in a capital case. I think opposing counsel mentioned that this wasn't objected to below. We did request that we did request what I was just suggesting, which is that the victim impact evidence be presented at the Spencer hearing, and that was rejected. And I think I'll close with the point about Payne being controlling. I respectfully disagree that Payne is controlling here. Payne deals with whether or not the Eighth Amendment generally prohibits a state from determining that victim impact evidence is relevant for the jury's consideration. That is not our system. Paragraph 2 is the only paragraph that in our capital sentencing system that governs what the jury can and can't consider. It sets out exclusively the aggravating circumstances in the preceding paragraph. It limits the jury's, or it prohibits the jury from giving aggravating weight to anything other than the aggravating circumstances. And we know for a fact that this isn't a mitigating circumstance. So we have this, we've poisoned the well essentially for every deliberation in a capital case in Florida by permitting this very prejudicial evidence, by permitting this evidence to be presented immediately before the jury retires to deliberate. So for the issue that we raised in point 1, though it wasn't discussed this morning, we'd request this court remand for the imposition of a life sentence. And for the remaining points, I respectfully request this court vacates his sentence and remand for a new penalty phase.
Thank you. We're adjourned.
All rise.